give you a notification so you can hit continue.
Okay, great. So I'll go ahead and get started. So thank you everyone for being here today. My name is Bailey Butler, and I'm going to be talking to you today about custody for kinship caregivers. So a little bit of background about me. I'm a senior staff attorney with Southeastern Ohio Legal Services. For those who are unfamiliar, Southeastern Ohio Legal Services is a nonprofit law firm. We represent 30 counties and we'll serve 30 counties in Ohio, and we serve low-income individuals and seniors on all civil legal matters. So basically anything that isn't criminal, we can handle. That includes family law, custody, child support, domestic violence issues, housing, evictions, fair housing, security deposits, those types of things. Consumer cases, car loans, debt collection, payday lending. We also do public benefits work. So there's a number of things that we handle, and it's all free for low-income individuals and seniors who are in one of our 30 counties. We're a legal aid organization. There's, I believe, 5 or 6 of them in the state. So if we don't serve your county, we can definitely hook you up with the legal aid organization that does serve your county. So I've been with Southeastern Ohio Legal Services for about 5 years now. When I first got started, I was working on a project called the Youth Law Project, which had me essentially embedded in a foster care organization, or an organization that was providing not only just foster care services or placing kids in foster care, but also serving those youth who were aging out of foster care, providing them with housing and services once they emancipated. So I got to learn the ins and outs of child welfare law and just kind of seeing the different things that families go through and what those youth who emancipate, like the difficulties that they encounter. So providing legal services to them was really eye-opening. After that, I mean, we're still kind of doing that, but we also got an opportunity to work on a project called the Appalachian Children Victims Assistance and Prevention Program, which is a mouthful. But what it is, it's essentially a project where we are providing services to help children who are victims of the opiate crisis and the families that they're currently residing in. And what we're seeing with that project is that a lot of these children who are victims of the opiate crisis or have had experience with substance abuse in their family are living with caregivers who are not their biological parent, and just providing services to those families as they need them to make sure that the child is safe and stable in the home where they're residing. So that's a little bit about me and kind of how I came to do this type of work and why I'm kind of here talking to you today. So without further ado, we're going to get started. What I'm going to talk to you about today, I'm going to define kinship because it means different things in different groups. We're going to talk about kinship placement through Children's Services kind of as a breakout because it is a little bit different. We're also going to talk about just custody in general and why it's important, grandparent power of attorney, caretaker authorizations, grandparent rights, and guardianship. So we got a lot to get through. So while, I don't want this to be a presentation where I'm just talking to you, so feel free to unmute yourself or jump in if you have questions. I'm usually much more comfortable giving presentations in person. Given the pandemic, things have been a little bit different these days, but it's much easier to kind of feel off the room to see how things are going and whether people are understanding what I'm saying. I talk really fast, so feel free to slow me down or stop me at any point or ask if you have questions. But right now I have a question for you. So what does kinship mean to you? When you hear the word kinship, what are you thinking of? Anybody?
Monica wrote in chat family.
Ah, yes, family. And that's what it is. That's the root of it comes from, right? Kin. It generally refers to a relationship between a child and their caregiver when the caregiver is not the child's biological parent. This can be a grandparent, an aunt, an uncle, a cousin, even the child's older sibling, or what courts term as the next friend. A next friend is just a legal term for anybody who is not blood related to a child. So they can be a godparent, a friend of the parent who's always been in their life, or even just the neighbor who the child had a close relationship with, or even a friend's parent who they had a close relationship with. So really that's what a next friend means. So kinship, that's what we're talking about generally, but it can refer to different types of arrangements and what that relationship looks like. So it can refer to an unofficial arrangement where the children just stay with the kinship caregiver part of the time or as they need. The caregiver has really no legal rights to the child. They don't have any benefits for the child. It's just, a safe spot for that child to land when and if they need it. It can also refer to a permanent custody arrangement where the caregiver actually has custody through a court order, or it can be actually a children's services placement, which we'll get into a little deeper. So under federal law, children's services are required to place children in the least restrictive environment possible. So ideally, children's services would never take a child if they weren't in need of, safety. So ideally, everybody would be safe and stable in their home, and they would get to stay with their birth families. When that isn't possible, the next best option is kinship care, staying with somebody that the child has a connection with. If that's not possible, then the child might be placed in foster care, a licensed foster home that essentially looks like a family setting, but isn't somebody that the child might know. Or if that isn't possible, there isn't a foster home or a foster placement that is available, or there isn't one that meets that child's needs, then the child could end up in a group or congregate care setting. But the ideal placement is if the child is going to be removed from the home, that they're going to end up with a family member or a kinship provider who has a relationship with them. In this case, whenever the Children's Services intervenes, the Children's Services goes to court and they take custody of the child. They have legal custody of the child, but they place the child with the kinship caregiver. So they give physical custody over to the kinship provider, but provide all legal responsibility remains with the state. I want to pause here and note that in 2018, there was a federal court order that required Children's Services to pay kinship caregivers who have children placed in their home by Children's Services, similar to the way that they pay foster parents. Ohio is not currently doing this, and if you do have a child in your home placed by Children's Services, and there's an open court case still on the parent, I'd love to talk to you about your rights under that new court case. So feel free to give me a call or send me an email and let's chat. But we'll move on.
So, this is Monica. I have a question about that.
Yeah.
Is that a federal law or a state law?
It's a federal law, so it's not actually a law. There's a federal law that says that they have to do this, and then there was a federal court case in 2018 out of Kentucky that covered Ohio and Michigan as well. Is a Sixth Circuit, and so it was a federal court decision interpreting a federal law, and they determined that states have to pay, and Ohio currently isn't. So that's something we're looking into.
Thank you.
So why is custody important? Well, custody is important for several reasons. And custody can mean two different things. So in the last slide, I was talking about how Children's Services might have legal custody, but the kinship provider has physical custody, and that can be a little confusing. So legal custody usually refers to major life decisions that affect the child, such as, where's the child going to school? How's the child getting a religious upbringing? Who has the right to sign medical care or medical releases? Those are all legal issues, and whoever has legal custody is the person who signs off on those and has the rights to make those calls. Physical custody basically says who is the child with and who does the child have the right to be around. So that can be who do they live with and who has visitation rights. Ordinarily, we just talk about it as one lump sum custody, because a court usually orders both legal and physical custody of the child, but it can be different, like in the Children's Services case. When I talk about custody, I also like to talk about emergency custody and temporary custody, because those often get talked about and lumped into the same conversation, and they're very different things, and it can be confusing. So first and foremost, there's no such thing as emergency custody or really even temporary custody. emergency custody is a term that attorneys and some people use for an immediate court order stating who should have custody while there's a longer custody battle. So an emergency custody is somebody goes into court and says, I'm going to file for custody of this child for the future, for ongoing, forever. I haven't done that yet. I need an order today saying that I have the right to have physical custody of this child and legal custody of this child while that case is pending. So whenever you file an emergency custody order, the court is anticipating a custody complaint or a custody motion either shortly to follow or at the same time. Temporary custody is similar, but what you're saying to the court is, I need a determination about what's going to happen to this child while the case is ongoing. I don't necessarily need it today, but I need it in the next few weeks. That way we know what the visitation schedule, what the rights look like while the judge is making the ultimate determination as to who has custody in the long run. So temporary custody does not mean that you only get the kids temporarily. If you ask the court for custody, the court is assuming that you're asking the court for custody forever, that you are going to be this child's custodian, that you are going to be the permanent and stable force in that child's life. That's the court's ultimate goal. So people get a little confused when they talk about emergency custody and temporary custody, because sometimes they just come to me and they say, I need temporary custody. I'm going to give this child back eventually. They're going to go somewhere, but right now I just need rights. And that's not what custody is used for.
So I have another question.
Sure.
So let's say someone is going, they're in the Army and they're going active duty. They're a single parent, and you're a grandparent that takes the children. What would that be?
I would recommend a grandparent power of attorney, and we're going to talk about that a little later in the presentation, and I'll tell you why at that point. Okay?
Thank you.
So custody, how do you get custody? You ask the court to grant you custody by showing that the parents are unfit. So in order to get custody, you have to file court documents, and we'll talk about that in a minute. But in order to the court to grant you custody, the court has to show that you have to show the court that both parents are unfit and that you are it is in the best interest of the child that you be granted custody. And custody isn't something that you can just give back to the parents. Once custody has been granted to somebody, like I said, the court's interpretation and what the courts want is to see is that you're going to be the permanent force in that child's life. So in order for custody to be given back to a parent or to go elsewhere, there must be a change in circumstances, not on the part of the parent, but on the part of the person who has custody. So if you take custody of the child and then somebody else wants to get it, or you want to give it back to somebody else, you or them have to show the court that something has changed in your life such that it is no longer in the child's best interest for you to be the custodian. So it can't just be that the parent now wants to step up and be a parent, or that they're willing to take the child back. It has to be something has changed in your circumstances to be that you're no longer the best person for that child. Just keep in mind that best interest of the child is always the most important thing. That's always what the courts are going for, and that's always what they're looking for whenever they're making determinations on who has the child. They don't like to see the child being volleyed back and forth because they want to make sure that, like I said, the child has a safe, stable home that can give them the structure that they need to thrive and to grow into adulthood. So why should you seek custody? Well, I talked to a lot of people about this. You need to really seek custody whenever you have been the sole provider for the child and you plan to continue providing for that child until that child is able to provide for him or herself. So you really need to think about that. You know, are you going to be willing to be in this child's life and provide for this child as the custodian forever? You know, until this child is 18 or beyond, because we know from studies that children aren't always self-sufficient once they turn 18. You know, it's 20s or beyond before they're able to kind of stand on their own 2 feet sometimes. And even though you may not be legally responsible for them, they still need, and the court's looking for them to have some place to call home and to have a soft spot to land. Are you going to be that for the child? If the answer is yes, then I also like to consider a couple other things. So you're willing to do that? Great. Does the child want to live with you? Are the parents constantly threatening to take that child away? If that's the case, then that could be causing a lot of trauma for the child. They could be getting very scared that, you know, someone's going to come and take them away from the place that they call home and the safety that they know. And if that's a concern and you're willing to provide for that child, then I would suggest filing custody. Or if the child is not safe with either parent, or you know has been abused or neglected while in the parent's care, and you're willing to provide for that child, then yeah, seek custody. If the child's been living with you full time and the parents have been absent and you're needing to do things for that child, and you're, you know, like get them medical care, get them enrolled in school, and you feel that you are going to be this child's provider for the rest of their life, then yes, seek custody. You might also consider seeking custody if you have that child's sibling, because there can be a real tight bond with the siblings, and just so everybody knows and feels comfortable that this is a family unit and this is how we're going to be living, that might also be a reason to seek custody. So how do you get it? In order to get custody, you have to file in the court where the order was, if there was a previous order. So if an order was in County A, you live in County B, you have to go back to County A and reopen that case in that court. If there was no court order regarding custody and you've had the children in County B, then go file in the juvenile court where the children are residing. You can also file where the parents are living, whichever is easiest. Paperwork can be county specific, so I do recommend going to our website at souls.org/gethelp and going to the family law tab and then seeking each county information for the counties that we serve. You can also probably get them from the legal aid organization that serves your county. But in every situation, you have to file a complaint if it's a new case, or a motion if you're reopening a previous case for custody. You have to file a parenting proceeding affidavit, which is also called a UCCJEA, which kind of tells where the child has been living and who might have jurisdiction over the child, if there's been any other cases open regarding the child. Also stating in your home whether or not there's anybody living in the home who has a criminal record or such that might put the child in danger. The court needs to know that as well. You also have to file a request for service, which is basically saying that you're providing a copy to the parents and making sure the parents are aware that you're filing this complaint. So we talked about why you should do custody, but why might you not seek custody? So you might not seek custody because you're not willing to provide for the child for the rest of their lives, or you're not able to, or it's not going to be a long-term solution for them to stay with you. That would be a perfect reason not to file for custody. Maybe the parent is truly and actively working on becoming a better caregiver and a stable present in that child's life, and the child really wants to be with their parent. I've seen many situations break down because the child really wants to be with their parent, regardless of what mom and dad have done in the past. That child, that's still their parent, that's still who they love, and whoever gets in the way of that, whoever tries to take them away or tries to, even for their own safety, make sure that they have somewhere else to be, they're going to be the enemy. And I've seen a lot of relationships break down whenever the children are like, I really want to be with mom and dad, and grandma and grandpa get involved. Then there's suddenly a breakdown in that relationship between grandma and grandpa, where it previously had been a safe place for that child to be. They no longer trust that situation or trust grandma and grandpa because they feel like they're taking them away. So that might be a reason not to seek custody at that point, just to be, you know, a soft spot for that child to land and to provide support as you can, while the parent is actively working on becoming a better caregiver. You might not seek custody if the child is actually safe with their parent, but the parent just needs some help or some resources to make ends meet. If the parent really just needs resources, that could be an opportunity just to provide that link to them, to get them resources, to get them help, to make them, you know, realize they can be a better caregiver. And if the child's safe, that might not be a reason to seek custody. Also, if you've not had a relationship with that child for a long time, or you've never had a relationship with them, that can be very traumatic for them to take them away from their parent. And especially if they don't know you, that can also just add to the situation with the children. So it could be a moment to pause and just say, you know, are they truly unsafe? What's the real reason I'm doing this? Is it just that I need a relationship with them, or is it that there's something truly going on that the children are not safe? So just a moment to pause before you actually seek custody. So what are the alternatives to custody? The grandparent power of attorney, which is what you were getting at, you were asking about, Monica. This is a signed affidavit from the parent granting the grandparent physical custody of the child. So the grandparent can use the affidavit to enroll the child in school, to discuss the child's progress with the school, consent to school-related matters regarding the child, or consent to medical, physical, or dental treatment of the child. Does not grant legal custody. The parent retains all rights to the child, so it doesn't do anything necessarily to cut off the parent. All it does is the parent signs an affidavit in front of a notary stating that they understand that the grandparent is going to have the child physically for a period of time. And they're usually good for a year. So this is great, and what I usually recommend that parents do, especially if they're going to be traveling or in military situations, because they still want to have that child, the rights to that child. They still want to make all the calls regarding, what religion that child's going to be, maybe what school they're going to go to, or what kind of school. Are they going to be in private school? Are they going to be in public school? The parent still gets to make those calls, but the grandparent, is the one the child's going to live with and can do everything that the parent needs that child or that grandparent to do on behalf of that child, like enroll them, be there day to day to talk to the teachers, to talk about school progress, or to get medical attention if needed. Now, this is if you can find the parent. If you know where the parent is, you have a relationship with the parent is willing to sign. A caretaker authorization is very similar to a grandparent power of attorney. It's the legal understanding that a grandparent has physical custody of the child. But the caretaker authorization is used only whenever the parent cannot be located, but you have made a reasonable effort to locate the parent. The court grants the authorization for the same reasons and up to the same amount as the grandparent power of attorney to enroll the child in school, discuss progress in school, consent to school-related matters, or consent to medical and psychological or dental treatment of the child. I do want to make sure I emphasize, though, that both the grandparent power of attorney and the caretaker authorization, the word grandparent is used. You have to be a blood grandparent in order to use one of these forms. You can't be the sibling, you can't be the aunt or the uncle. It is very limited in Ohio. The only carve out in Ohio is for the grandparent. So how do you get them? The grandparent power of attorney and caretaker authorization forms can both be found on our website. They're not county specific, so I think regardless of what county you're in, you can still go to those sites and print them out. You have to file the correct affidavit, meaning you have to file the grandparent power of attorney and have the parent notarize it. If you know where the parent is, you have to file the caretaker authorization if you have no contact with the parent, and then you sign it and you have it notarized, your signature notarized. Both of them have to be filed along with the parenting proceeding affidavit or the UCCJEA. They have to be signed in front of a notary. The parents have to be notified in writing that you're filing it, and you have to file it in the juvenile court where the grandparent resides or any court that has jurisdiction over the child. This has to be done no later than 5 days after it's been signed, and you have to put in a receipt showing that you sent the notice to the parents by certified mail. Grandparent power of attorney and caretaker authorizations can be terminated or revoked. The parent can revoke the authority granted to them at any time, as long as they do it in writing to the court where it was filed. It can be revoked by the juvenile court on their own motion or on their own order if they believe that the grandparent is abusing that right, or that something was a little fishy when it got filed. It can be automatically revoked if the child is no longer living with the grandparent, or it'll be automatically revoked if either the child or the grandparent pass away. Now, in a situation where the parent revokes it in writing, a lot of people will say, well, what if they get mad at me and they decide to revoke it just out of spite? Well, that could happen, but you have the opportunity that if you truly believe that it is in the child's best interest for them to remain with you, even after that the parent has written to the court and revoked the authority, you can file for custody within 14 days of that and keep physical custody of the child, and ask the court to award you temporary custody while the ongoing custody complaint is pending. And the court can choose to determine whether or not the child should remain with you or whether the child should go back with the parent at that point. Once terminated, the grandparent has to notify any schools, healthcare providers, the courts, and the other parent that either that the child is no longer living with you and it's been automatically revoked, or whether the parent or the court has revoked it on their own. Another question I often get is about grandparent visitation rights. Grandparents can receive court orders for visitation when the parents were married and they decided to terminate their marriage and separate. If the parent of the child is deceased, or if a child is born to an unmarried woman. In Ohio, Ohio has what's called unwed mother rights, meaning that the mother of the child has full custody of the child unless the father goes to court and proves paternity and a court orders visitation for the father or custody to the father. Up until that point, it is presumed that only the mother has custody. In these cases, the court will still make the determination based on what is in the best interest of the child. And it's important, that you can kind of establish that you've had a relationship with that child, or that you have been alienated from that child and have not been allowed the opportunity to have a relationship with that child. You have to file a motion to establish visitation with the court. If there's already a court case open, like a divorce or a custody action, then you file in that proceeding while it's ongoing in that court. You just file a motion to intervene, or just file in, your motion with that court. Otherwise, you can file where the child lives, in the juvenile court where that child lives. And like I said, generally these are in the juvenile division, but occasionally if there's been a divorce or something that you're trying to intervene in for an order, that might be in common pleas. But generally it's going to be in juvenile court. Now, the only other thing I like to talk about when I talk about custody and these types of issues is guardianship. I do want to kind of red flag this though, because guardianship is not a substitute for custody. It is something completely different. It often comes up because people will say, should I get custody or should I get guardianship? And really, guardianship isn't for these types of situations, which I'll explain. But in some circumstances, people prefer to go the guardianship route and it can get a little confusing. So guardianship is a probate court order appointing a guardian to make decisions for the minor. It's typically only used when both of the parents of the child are deceased and the child has received a financial award, like something out of the parent's will or something out of a trust that the parent set up. Then a guardianship will be appointed to make sure that those funds are being used to benefit the child. It is not used to replace custody. Sometimes people will file in probate court for guardianship, and you're more likely to file it all, pay for the filing fees, get in front of a judge and in front of the probate court, and the probate court to say, actually, this should be a custody order. You need to go back and start over. So I usually really caution people filing guardianships for custody of minors. But in order to get a guardianship, the court will hold a hearing to determine whether a guardianship is appropriate and if the person filing is a suitable guardian. The guardian has to submit to fingerprinting and a background check. They have to attend classes before they're actually named guardian and every year during the guardianship to go over the guardian's duties. And the guardian every year has to submit a written report to the court. So it's also a bit more taxing on the adults overseeing the child. So another reason, to kind of pause before filing a guardianship.
So I have another question. I just want to clarify.
Sure.
That the guardianship is just solely fiduciary. It's a financial responsibility.
So yes. They do have to make sure that the needs of the child are cared for or taken care of, but it's usually with the financial pot of money. So like they've been given a trust, and that trust is to make sure the child is cared for. And so we're going to make sure that the child, sometimes with a disability, they're in whatever hospitalization situation that they need to be in, or they're in a group home where they need to be, and that's being paid out. That kind of situation.
So if you have custody, do you automatically also have guardianship, or would you have to file for both?
So you don't necessarily have the rights to the financial pot of money that that child might be entitled to, but you are financially responsible for the needs of the child with custody.
Okay,
Great questions.
thank you.
I don't know why this was cut off, but I can make sure that gets edited. Does anybody else have